We see all kinds of problems in the litigation world. I'm the fixer.
I've got a new situation that's come up. When they were presented with this information with the county record showing the property line, they've suddenly stopped responding.
I had this same case. Sellers had a handful request to the HOA to repair the roof because they had leaking issues. So we reached out and said, hey, HOA, you need to replace the roof. We're going to lose this deal. And they refused. In that case, the sellers replaced the roof, closed the deal, and then sued the HOA after the fact for the cost of that roof replacement. Spend a couple hundred or a couple grand with an attorney on the front end, or you're going to spend tens of thousands, hundreds of thousands of dollars with an attorney on the back end.
Yeah.
Sometimes being right is not the right business decision. Sometimes just getting someone to go away is the right decision in exchange for a release. As soon as you go to court, you have no control. You're giving everything to either a judge or a jury or an arbitrator to make that decision for you.
Welcome to another episode of the Astor Podcast. I am Shelly Vincent, your host for this podcast. I am the owner of Astor Real Estate, but I also love getting into lots of topics, whether it be legal, political, development, economic, just an inquisitive person. Today, I have a great guest I've known for several years now. This is Andy Gibbs. He is an amazing attorney here in Colorado. And so, Andy, I kind of wanted to, give us some background on your experience, your work, and specialties.
Hi, everyone. Thanks for having me here. Always exciting. I've been practicing law for about 25 years. My focus has been on commercial litigation, primarily real estate, construction, and corporate, with pretty heavy emphasis on real estate. And we see all kinds of problems in the litigation world. So it's mostly all problems. My partners are on the transactional side. They put things together. I'm the fixer. So we see issues with real estate transactions, easements, development deals, anything that can go wrong in that space. We have dealt with it in some form or another.
Yeah. And as an employing broker, I'm kind of the fixer too, which is how we met. We've unfortunately done quite a bit of work together. And so, one of the things I've been needing to talk to you about, I was looking forward to today, I've got a new situation that's come up. And this is right down your alley. I thought we'd talk about some of the issues we have in transactions, especially when it involves HOAs. Right now, I am representing a seller for a townhome in Aurora. And the sewer inspection found a significant blockage, 37 and a half feet out from the house. And what's funny is this HOA called me within an hour when I put a sign in the yard saying that those are HOA grounds. You're not allowed to have any signage. Come get it immediately and pull it out. Well, those same grounds are where that sewer pipe issue is. The HOA documents say that the HOA controls anything outside the property line. So we were quick to contact them, said, hey, we have a big sewer issue. This is outside the property lines. Well, they were real quick to say, oh, we need to have a survey, find out where those property lines are, see where it lies, and we'll talk about it. Well, I pulled up all the county records, and the property line is the imprint of the house, and they own all the grounds. Well, when they were presented with this information with the county records showing the property lines, they've suddenly stopped responding.
Interesting. Well, it's curious they referenced a survey because the way an HOA is created, it starts at the level of the plat. And the plat is what defines where not only all the property lines are, but where the boundaries begin and end for the individual units, whether it's a multi-level condominium high-rise, townhomes, or single-family homes.
Mm-hmm.
So they wouldn't typically look to a survey. You would look to the declaration, the definition of the unit, the house, whatever those individual components are, how that relates to the plat, and then looking at the maintenance and repair obligations in the declaration, it'll typically say, it'll often carve out certain areas. It'll get a long list of like plumbing, utilities, and so on, or it'll simply say anything inside or outside the boundaries. Yeah. So the first issue is, why are we debating responsibility? So is there any reason why, for example, is there an exception that says we're responsible for everything outside except for the sewer lines? Is there anything like
Mm.
that?
No,
No.
it includes sewer lines in the description of the responsibility.
And the HOA, are they simply denying it or are they just ignoring it? Or both?
Ignoring it.
Okay. So then the next step is we want to look at a couple of things with the HOA. There are 9 responsible governance policies that every HOA is supposed to have by law.
Mhm.
And in 2022 and 2024, there were updates to that, to the Colorado Common Interest Ownership Act, that require certain things to be in those governing documents.
Mhm.
So we want to look at those responsible governance policies for 2 reasons. One, we want to make sure they're compliant with the law. If they're not
Mhm.
compliant with the law, it gives us another piece of ammunition against them. They are compliant with the law. It's going to tell us how to navigate a conflict with the HOA. They're typically going to require mediation and some notice process
Mhm.
first. So we want to follow that notice process and say, hey, HOA, the governing documents say this, you're doing it incorrectly. This is what we demand. And if you're not going to agree to that, we're demanding mediation.
Mhm. Okay.
That should begin the conversation. And then if that does not work, then the next step would be file some kind of a lawsuit to force their hand.
Yeah, and my thought process too is this property is under contract. The sellers have obligations as to closing date, things being repaired, and we've already had to extend them multiple times for this. And at some point, the sellers, or if this drags on or it goes that route, there are other damages that are going to come into play outside of just the work that needs to be done. So to me, it would behoove the HOA to, if they, if it's that obvious, they know they're responsible to move quickly to avoid any further issues to come from this time lapse.
But you're operating on common sense and logic. And
It's a weakness of mine.
and sometimes boards of directors do not operate that way for whatever reason. And
Mhm.
it begs the question, do we have a bad board? Do we have a bad property manager? Sometimes property managers effectively become the board and they take on too much responsibility in decision making, and the board says you handle it. They can get sometimes unnecessarily aggressive, and in some
Mhm.
cases very ill-informed. So you never really know if it's the board or the management company in this
Mhm.
case. But uh, that said, your point raises a real issue of the 2 types of relief you might need to seek. The first one is forcing your hand. The second one
Mhm.
are the consequential damages of a lost sale and what that
Yeah.
looks like if it goes south. The HOA would absolutely be responsible for that because they have a variety of obligations and responsibilities in the
Mhm.
declaration that require them to effectively look out for the best interest of their owners.
Yeah.
So if the demand letter, when we're talking about asking for mediation and
Mhm.
beginning that conversation, um, when we go down that road, we want to identify these other issues. Hey, if we lose this sale, you're on the hook for it. This is what it's going to look like. This is the damages you could be facing. You need to take care of this. Another option here would be if the HOA is refusing to cooperate, you can perform self-help. If you kind of weigh the odds of if we go down the legal route, the mediation route,
Mhm.
that's going to be weeks, maybe even months or
Mhm.
longer. If you file a lawsuit, it could be up to a year, and that's not going to help your situation when you're trying to close a deal.
No, I mean, if the sellers just have to do the work themselves, that's one thing. But also, we're doing work on property that's not ours. There's a liability to
There,
that as well.
there is. Let me tell you a story.
You have
So
one.
I had this same case a couple years ago, but instead of a sewer line, it was about a roof.
Mhm.
And in that case, they were townhomes, and the association is responsible for the exteriors. And the sellers had a handful of requests to the HOA to repair the roof
Mhm.
because they had leaking issues, and they refused to do it. They looked at it once and said, "It's fine. The repair is all you need." And then at that point, they continued to refuse to even make the repair. And it was an issue on inspection objection where they wanted a new roof.
Yeah.
So we reached out and said, hey, HOA, you need to replace the roof. We're going to lose this deal. And they refused. So in that case, the sellers replaced the roof, closed the deal, and then sued the HOA after the fact for the cost of that roof replacement, which technically was a common element. It was a, limited common element for being technical that the HOA is responsible for. And although we did not get to trial, we did settle it, and they paid for the roof and our legal fees to get there. So while satisfying the attorney, it's immensely frustrating for an owner to go through that.
Yeah.
So you're right, there will be additional liability. You have to weigh the odds here. How bad do we want to close the deal? How bad do we want to incur potentially tens of thousands of dollars with an attorney to try and get this thing done? So what you could do, you could send the HOA notice and say, okay, fine, we're gonna replace that line, and then we're coming after you after the fact. And you can thank us later because it'll be a whole lot cheaper to deal with the cost of repair than the more complex issue of a lost sale.
Yeah, that's true.
And if you have a qualified plumber, excavation company, everyone that's going to get out there and do this work to mitigate that potential liability you're concerned about by working on something that's a common element, that can reduce that factor. So in terms of your risk of what if you screw it up, at that point, it's their problem.
Yep.
So that could be the fastest solution, is just to get it fixed and then pursue them afterwards. You're also liquidating your damages that way. What that means is if you providing the sum certain that you're going to chase, if it's $10,000 to fix it, now you're chasing $10,000 and the legal fees to get there.
Right.
If you miss a sale and the buyers walk away, that is a little bit more.
That's more subjective.
It is more subjective.
Yeah.
What exactly are we losing here? What if it takes 6 months to sell and you end up selling it for more? Well, then it kind of changes things. If you sell it for less, well, that's easy. Now we can say, I had a buyer for X price, and now my next buyer is X minus 20%. And then you're chasing that 20%.
Right.
Are there broker fees? Well, yes, but those don't apply till it closes. So is that going to create a problem? Are there costs the sellers incurred addressing inspection resolution issues? Is that recoverable? Maybe, maybe not, because you're probably going to have to do it on the next sale. So by liquidating your damages, you're kind of cleaning the issue up and you're going after them for a specific number. That might be the cleanest way to get there.
Okay. And one of the things too is we're not providing a seller's property disclosure because it's an estate. The sellers never lived in the property. But one of the biggest things I've seen most often, and I'm sure you're probably seeing more, especially with the stress market, is more lawsuits coming out of non-disclosure.
I'm seeing more now than I've ever seen in my practice. And these tend to come in waves. The first wave we saw was following the COVID craze, where people were waiving inspection objections. And that led to a whole slew of issues because the buyers became completely reliant on the seller disclosure form. Sellers are humans; they're not perfect. You miss things. I in my own house selling years ago, I had completely forgotten about a water event, and buyers had found it searching for insurance claims. And they called me out and I said, "Oh my gosh, I completely forgot about it. Here's all the record." Whereas when you have an inspection report, you can always waive the objection, but you don't want to waive the inspection because that inspection report is a bit of a savior for both parties. It gives the buyer a very comprehensive look into the house of what's going on. Whatever they find there, in some respects, it protects the seller, because if something pops up on inspection that the seller didn't disclose, well, now the buyers are aware of it. They can address it in the objection process. So with that waiver of inspections, we saw a big wave. Right now, I don't know why we're seeing so many. We're
Mhm.
getting as many on the defense side as we are on the prosecution or the plaintiff side of these.
Okay.
And I think it might be because the market has leveled out.
Mhm.
Buyers are now
Mhm.
starting to, you know, not that they're paying less, but they're still paying at market value.
Well, as much as they're paying for the house, they're gonna be much more particular about things that go wrong. And you and I haven't talked about the market recently, but obviously here on the Front Range, it's weird. It's really weird.
It's in the process of adjusting,
It
which is
it really
in
is.
your world.
Yeah,
Yeah.
I can do, I guess, open houses on 600 to 800, which is most of the properties around here for sale, 6 to 800 range, and crickets every week. I do an open house at a property that's 1.2 to 2, and they beat the doors
Really?
down.
Why is that, do you think?
I think you either have money or you don't right now, and it just seems like the wealthier Ford have the money, or they're not so tight with what they need. We've got concessions for rate buy downs. There's much more negotiating power to higher price range than a lower price range. But it blows my mind. I had an open house for a friend yesterday at a 1.2 million.
Mhm.
Now it was a good deal. It was a 400 square foot house for 1.2 million. So it was a great deal, 4-car garage. And at no time did I have less than 6 people's house for the 2-hour period. It was unbelievable.
And you're not seeing that in the sub 1 million range.
I get crickets, just crickets. And but it kind of shows that stress on the market where but the problem is the median household purchase is 591 in the Front Range area. And so that's your most buyers, your most affordability, which is evaporating quickly. But when you get into the closer to 2 million, we see many more buyers. Breckenridge is doing great right now. It just oddly enough, if they'd stop messing with the short-term rental issues, it would be even
Yeah.
better.
Are you seeing differences in the front range between the urban areas and the suburban area and the more remote areas?
People keep wanting to go further and further out. So one of the fastest growing towns in Colorado right now is Elizabeth. And
Wow.
so, that's about 20 minutes out from Castle Rock. Castle Rock in 2009 had 40,000 people. We're about to cross 100,000.
Holy
And
moly.
yeah, so we had this massive flood down from Denver
Mm.
during COVID, but now it's actually spreading out even further. And so we're seeing more of that distance. Lyman, one of the fastest growing. We've watched Conifer take off, but
Yeah.
even the home values fair play, Alma, outside Breckenridge,
Mhm.
instead of on the north side, the Dillon area,
Mhm.
it's moving southward. So we're seeing a tremendous amount of interest more in that fair play South Park area as well. So
Wow.
it's been really interesting to watch.
Hmm.
The public and where they're going, what they're doing now. Uh, I've never seen so many houses for sale around 6 and University.
Interesting. And it's funny, we'll probably, in my world, we often are tracking a little bit behind that because as the sales start to close and
Right.
problems arise, we start seeing them.
Yeah, you could have a 2-year lag.
Absolutely. So now, as you said, I'm curious to see if we'll start witnessing more seller non-disclosure cases
Mhm.
kind of getting farther away from the urban area.
Yeah. And, I'll go back to the short-term rental change of
Mhm.
Summit County. Blue River
Mhm.
put in a place an immediate moratorium. Immediate, not retroactive,
Mhm.
immediate moratorium on short-term rental licenses. Well, it was, not a necessarily public decision to do so. It was a small group of people, but you had a massive amount of real estate agents and contracts affected by this. As the people buying these homes that currently have an STR license, suddenly they're non-transferable. Let's say you're in the middle of a contract, these deadlines are passed, and the government comes down and says, or the HOA, or the association, whatever it is, says, no, we changed it. What do you do?
Not a lot you can do. It is tricky. As long as the seller has played by the rules, disclosed everything, it's
Mhm.
out of their control. Where we do see some issue, it's easier for a seller to say, I didn't know my local government was taking these steps. I don't pay attention to that stuff. It's not my world.
Mhm.
That's a little bit different. And it's also out in the public sphere where arguably the buyer would be on some kind of constructive notice of that.
Yeah.
At the HOA level, it's more interesting because there is a frequent issue I'm seeing coming up around the state where boards are coming to us and they're asking about how do we limit STRs? How do we stop
Mhm.
STRs? Or in some cases, how do we reverse an STR prohibition so we can use them? Do we
Mhm.
grandfather them in? The list goes on. That process at the HOA level provides the seller plenty of notice. And I've seen
Yeah.
more than my fair share of issues where after the fact, after closing,
Mhm.
the buyer, now owner, learns that, hey, there was a special assessment that got passed a couple months ago and it
Mhm.
just now hit. Or there was an STR amendment that had been floated and it just now hit. And so that is it's really important for the buyer not to trust the seller
Mhm.
and be very adamant at the due diligence level.
Yeah.
Some boards and some management companies are not that organized, and they don't always have really great records, or they're just not on top of it. So it's incumbent on the buyer's agent to really lean on the seller's agent and even go around the seller's agent working exclusively with the management company
Mhm.
or the boards. I need this information. I need all the board meeting minutes for the last year.
Mhm.
I want copies of all the resolutions, any amendments. Ask them specifically, is there anything that may be interest to the buyer? Are they changing anything in the declaration? Are short-term rentals available here? Are they
Got it.
not? What's the tenor of that conversation around here?
Mhm.
Is everyone for it? Is everyone against it? And it's a huge issue. I have a situation right now in Grand County in Fraser where there's a community of about 70 or 80 homes. Uh, this about the majority, maybe just over half, are full-time residents. And the rest of them are part-time residents around the country and Front Range.
Mhm.
And the full-time residents want to eliminate STRs. And in order to do that, they have to amend the declaration, which requires
Uh,
67% of the owners to sign off on it.
mhm.
And they've got somewhere over 60%. Is it 67? We don't know. But all of these other owners and prospective buyers are very concerned because that's how they can afford the place.
Exactly. Yeah, my husband and I have always wanted to own a second home, all my area and stuff, but it would be, you know, being able to take and rent it out to pay for itself.
Mhm.
But with what Hart County's proposing, what Summit County's doing now, it creates an atmosphere. Now that said, I'm a huge fan of private property rights. I mean,
Mhm.
people should be able to do with their property what they want to do
Agreed.
as long as it's not dangerous. However, we went to Bailey a lot, and we'd love to get away for the weekend. Airbnb, it's great. But if you pull up a map on Airbnb of what's available, I swear it's almost half the houses. And when
Mm.
you do have a massive affordability, low inventory uh, in an area, that will drive costs
Mhm.
up. And so I feel like there is like a delicate balance of how can we provide enough housing for everyone,
Mhm.
be a good healthy market, but also allow people to do with their houses, what they see fit.
Yeah, it's a very common discussion. How do you meter that demand?
Hmm.
Too much is too much, and not enough impacts the other end of affordability too.
Right.
So finding a way to have either a certain percentage allowable, a grandfathering of some, maybe a changing of the guards where you are allowed to do it for a period of time and not another period of time.
Hmm.
There's a lot of proposals that are out there. Each one merits a lot of debate. And
Yeah.
each one is, I mean, you can't make everyone happy. So finding a way to drive it down the middle is ideal, but it's really tricky.
Hmm.
Typically you either allow short-term rentals or you don't. And it's really hard to meter it. Think of the problem you would have in a community if you said you can only have short-term rentals for this amount of time,
Right.
whether it's a period of a year, a season, over a decade. It does get challenging because the more variables you put into play, the more you have to rely on people to cooperate, or be responsible. the board to be active.
Right.
It's hard to do.
And I noticed, most families are busy. They're running their lives. They don't have time to really get involved. But that usually leaves a very specific demographic running these HOAs,
Mhm.
whose interests may lie different from a lot of the residents.
Yeah.
Trying
And
to tiptoe around.
yeah, I mean, I feel like the good boards
Mhm.
are made up of members that don't want to serve. They're doing it
Mm,
because they feel an obligation to their community. They are honoring the governing documents and making sure that they're serving their purpose. Preventing the person from having loud parties every night, having the bright pink door,
yeah.
causing problems. The reason you want an HOA is to maintain some order in your community.
Mhm.
But where I really see the problems, and it's again and again and again, particularly when we are suing HOAs for board malfeasance, board overreach, things like that,
Mhm.
are the board members that absolutely love it. And
Mhm.
they're not changing over because very few people want to run for the board and serve on a board.
Right.
If the members stay on it for too long and they're too excited to do it, they're the ones that create bad stereotypes of the walking around with the clipboard.
Mhm.
They're hyper enforcing and being overly strict and making it really difficult where you start to hate your HOA and it
Yeah.
starts to create more problems than it solves.
Mhm.
So finding that balance, it's hard. And we just had a community where there were two board members that have been on for almost a decade, and they were causing everyone all kinds of brain damage with how they were enforcing the architectural control guidelines. And it
Uh-oh.
was just getting out of control.
Mhm.
And at the last annual meeting, we helped the community, who represented about a dozen or so individuals who needed some talking points to get in there and express to the community why this is a problem and why these individuals are not helping the community, but they're actually hurting it. And they're hurting sales because the local brokers knew that's a tough HOA to buy
Oh, yeah.
into.
I mean, as
Yeah.
an agent, I will absolutely be able, tell potential buyers, like, okay, this house is very limited, that you need to be aware of the HOA.
Yeah. If you want to remodel, buckle up, things like that.
Yeah.
So it ended up working. And these two board members, it was a 5-member board, the two of them were up for reelection and they didn't get reelected. And they got two other individuals who were sophisticated,
Alliances.
community minded folks to get in there.
Uh-huh.
And then it created, in a healthy way, a divided board.
Okay.
So now that 5-person board, the 3-2 vote and 2-3 votes and all of those, now all of a sudden it's starting to operate a little bit better.
Okay.
And they're going to start changing how they enforce the governing documents, which
Mhm.
is within reason, and to be reasonable on when they're saying no and when they're saying yes, as opposed to being hyper aggressive, making it very, very difficult and pushing agendas that don't really align with the community interest.
Mhm. So I agree with that. Now, for like all these short-term rentals, the non-disclosures, how often are you seeing the agents or brokerages being pulled in to this with E&O claims or
It's a great question and fairly frequently. And there's usually two reasons. As an attorney, when we get a buyer that comes to us and says, hey, I've got a non disclosure problem, oftentimes, not often, periodically, the sellers have left the state. They don't have any money, and that, maybe that sale wiped out all the debt on the property, but they didn't get much, or they are having financial issues. So realistically, if we go to court and win against the seller and there's no pot of gold at the end of that rainbow, then you're just paying your lawyer a ton of money, you're winning, and it's not worth the paper it's printed on.
Mhm.
In those scenarios, and generally, one of the things we ask is there any way the seller's agent knew anything? Most of the time they don't, because good seller's agents are going to hand their clients the property disclosure form and say, you need to fill this out. And, I can answer questions, but I'm not going to fill it out for you. Occasionally, the seller's agents get really involved in those things. We
Mhm.
see some seller's agents that are also property developers. So sometimes they will actually own the property. And so you have the seller's agent, that's also the seller, and the developer,
Right.
therefore the flipper.
I see lots of issues with flippers and non-disclosure or, putting lipstick on a pig type
Absolutely.
situation.
So the one duty a seller's agent owes to a buyer is to disclose adverse material facts.
Mhm.
When we find out that the seller's agent knew about these problems, then we are going after the seller and the seller's agent because
Mhm.
they knew about it. Now, the buyer's agent is not immune from liability either, particularly with newer buyers, less sophisticated buyers, where they're really leaning on their agent.
Mhm.
An agent has a duty to recommend expert advice and look out for the client's best interest.
Yes.
I've seen a couple times where buyers said, I'm really worried about this crack. And the broker says, I've been in construction my whole life. Don't worry about it. The right answer is you need to talk to an engineer. Let me get your name or go
Yep.
find an engineer. There's a problem with the contract, the question about interpretation. You should talk to a lawyer. You should talk to a plumber. And the list goes on. If the buyer's agent isn't doing that and the deal goes south related to that missed issue,
Mhm.
now we have a potential claim against the buyer's agent.
Right.
And it's not uncommon to have a seller non-disclosure case where both the buyer's agent and the seller's agent are on the receiving end of a lawsuit, and it triggers their email
Uh,
insurance.
I've
Other
seen many of
insurance.
them. I
Yeah.
mean, many of them, and especially when I was, employee broker for larger companies, there's obviously they see dollar signs.
Hmm.
And so, I've been, I always joke I felt like Donald Trump the amount of times I'd get served,
Hmm.
just as being the employing broker
Oh yeah.
as part of it. So I absolutely agree with that. I think too, when you're talking about this disclosure, very often the agents are not aware. The seller doesn't disclose, but I
Yeah.
think usually through keeping communications in writing, preserving as much as you can, that agent can very well defend themselves if the agent truly had no understanding of it. I've had I just had another issue on a mediation where the buyer's agent had a plumbing company she worked with that she really liked. I represented the seller. The They requested an inspection objection, some plumbing work to be done. One of the items was overlooked in it, and it ended up to a basement flood. And the sellers were not aware that they had overlooked it. They were sent their invoice. They paid the invoice. We provided a copy of the invoice that worked to the buyer's agent. And then the buyer's agent didn't review. I guess they didn't look on walkthroughs. It had been done or whatever happened. But then they came back after the house flooded and tried to come after us for not completing the work. It was quick to say, we used your plumber you required us to use as part of the work. We were provided with the receipt for work and we provided it to you. As the buyer's agent, if the buyers are objecting to something, it is on the buyer's agent to ensure that work is
Yeah.
completed. And so we were like, and it just kind of went away, but it wasn't a huge. They did have insurance that covered it. It was only just the co-pays, the deductibles and stuff like that that they were looking at. So nothing huge ended up out of it. But it's when I always have issues when they're like, you have to use this person.
It's true. And to your point on documentation, it's huge. And documentation doesn't have to be complex. It just has to be something that you can look back to.
Mhm.
And a great way to think about it is the confirming email, the confirming text. Could be either one that says, hey, you mentioned that crack, that leak, that plumber.
Now that home inspector, he didn't find it. You said to use him. I mean,
Yeah.
all the time.
And it's really important not to be aggressive, not to be adversarial.
Mhm.
Don't be a jerk. Just be nice, be professional, even when it's difficult, even when you're in conflict. It is so critical to not take any swings at someone. And just, especially if
Mhm.
you're having a hard time with your client, you've been butting heads, there's a lot of tension there. You have to look at every communication like it's going to be on the front page of the Times or it's going to be in front of a judge.
Yes.
And while it feels good at the time to say, I can't believe you did that or you're so wrong, in the end, you're the one that looks like a jerk. And if your client is sending really, or the other broker for that matter, adversarial communications, insulting communications, things like that. Just ignore it. Don't engage. Get to the issue. But above all, you're just confirming, hey, let's do this. Thank you for the call. I agree. We're going to do that.
Mhm.
It's really simple. And 9 times out of 10, you're never going to address it again. But that one time when something does pop up and you've got that note, you've got that email, or someone says, well, you never said I should talk to a lawyer. You never said that. And you look back and say, well, hey, you said your parents were lawyers and you knew all this stuff and you're not going to pay for that kind of thing. Here's the text. That's the protection against failure to advise.
Yeah.
Really important.
And Colorado just passed new legislation that reinforces the NAR settlement rules in our contracts. So get ready. We're going to have more contract changes coming up for this next year. But it also has a line in the legislation about requiring the statement from agent to their client to consult an attorney, like or to urge them in every transaction. And and that you've seen me copy you in on several things during the time. It's like, hey, you really need to talk to an attorney. Hey, you really need to talk to an attorney. And I think that you're putting yourself for liability. You really need to talk to an attorney. And so, that I do. So many people say, I have an attorney. I have it. I'm like, you obviously don't.
When someone says I have an attorney,
Mhm.
I question it. When someone says my attorney is so-and-so, they probably have an attorney.
Right.
And it's these situations where a lot of individuals, especially at the buyer's level, they're putting all of their financial resources into this property and they're pretty maxed out and they're afraid to spend several $1,000s on an attorney.
Oh, yeah.
Understandably so.
Mhm.
The relative cost of a couple $1,000s front end to a house that's $500,000, $1 million, whatever it is minimal. What we say all the time is, look, spend a couple hundred or a couple grand attorney on the front end, or you're going to spend tens of thousands, hundreds of thousands of dollars with an attorney on the back end. Get it resolved first. Ask the hard questions first. Navigate those issues now. And an attorney just says, hey, I've looked at it, everything's great, and you spend a couple thousand for that, that's not a waste of money. You're buying that assurance, because a lot of times they will find something. We find issues in title commitments, title insurance frequently, where the title company misses things.
Yeah.
We discover issues where sometimes the deed doesn't match the purchase agreement. There's a whole variety of issues. It's really worth having someone look at it, because hopefully stay out of our office on the back end when it's really expensive and it's really stressful, and it is no fun to be dealing with a litigator.
No, I agree. I've been in some cases with Neil.
Yes, you've been through that when everyone starts fighting, and
Yeah.
it's hard. And as individuals, you're typically paying out of pocket for that attorney.
Yeah.
Brokers, you have the benefit of your errors and omissions insurance, where for a deductible, usually $5,000 or $10,000. After that, you have a free lawyer that's going to go fight like crazy on your behalf.
And when I started my company, and I've dealt with E&O policy so much and agents and defending, and I'm going to be honest with you, I'd say 90% of the time when there's a claim made against us, we're not liable.
Yeah, I don't doubt it.
It's an attempt, at that for just about every company I work for. My agent deductibles were $10,000, and whether or not they were at fault, that deductible could kill an agent. Anyway,
absolutely. And it's a question we ask a lot of agents. We're helping agents through these issues. The first thing we ask is, how much is your deductible?
Yeah.
And whether it's 5,000 or 10,000, that becomes part of the equation, because if it heats up, you're going to pay that deductible amount. If we can get rid of this case
for less
than that, or up to that amount, do that all day long.
Yeah, and you've done it twice for me.
Yeah, now you're not making that claim. And sometimes being right is not the right business decision. Sometimes just getting someone to go away is the right decision in exchange for a release.
Yeah, that's a hard pill for me to swallow.
It's a hard pill for anyone to swallow.
But I get it. I get it.
On the way here, I was on the phone with the client and we're pulling our hair out. Mine's already cooked, but I was trying to. And we've got this situation right now. It's a $20,000 problem with these extremely difficult buyers. And my clients should not pay them, but I think they need to pay them.
Just make it go away.
Just make it go away. Yeah, it's hard. And it's a business decision. It's not about being right. It's about putting this to bed. And
Mhm.
I talk myself out of work, and I talk clients out of hiring me all the time. I say, I'm expensive. You don't want me, pay them and keep me out of your life. Yeah, happy to come in and help. But if you can buy certainty, this too shall pass. Once it's done, you're never going to think about it again.
Yeah.
But when you're really in it, these cases can go on for years.
Yeah.
And it's really
Absolutely.
stressful to be in. And everyone talks a big game. I'm going to call my lawyer. I'm going to file a lawsuit. It's really unpleasant. So
Mhm.
crossing those T's, dotting those I's on the front end is a great way to avoid it.
Mhm.
And then if you're in it, you want to get out as quickly as you can. And if you can't, either because you're in a bad position or the other side is decidedly unreasonable, then that's what lawyers and courts are for. And we do our best to fix that and nip it
Mhm.
as quickly as possible.
Yeah.
But people are difficult.
They are, and when I started after knowing my history for all these other companies, these E&O claims, the deductibles, I made the choice to get an umbrella policy for every agent in my office with
Mhm.
a $1,000 deductible, and it costs a little more, but I think it's a great benefit to have agents that are better protected and know and it's not if, it's when
It
these things
is.
happen that they're not gonna have to lose so much just to defend themselves.
And the benefit to that is they can quickly get counsel involved without the concern about cost. And
Exactly.
one of the most valuable parts of an attorney isn't the bulldog going after him. It's getting another opinion on it. And a lot of times it's an opinion you don't necessarily want to hear, but you need to hear,
Mhm.
which is not unlike going to a mediation. Having that neutral person
Yeah.
that is loyal to the resolution and not to either party, and they're having that difficult conversation with both sides to say, you really need to back off this. You really should consider that. Because a lot of times you get tunnel vision because you're in it and you're emotional. And it's hard not to.
Mm.
So to be able to tap that, whether you've got an attorney on call that you can ring and say, hey, I've got a question. What do you think? Those 5 and 10 minute phone calls are the game changer that often talk people off the ledge or send them in the right direction. So like calling an attorney quickly, whether it's through that E&O carrier and
Mhm.
saying, it's time, I need to pull the button, pull the ripcord, let's do it.
Yeah.
Or you just have an attorney you can call. It's critical. It's
Mm.
really important.
Yeah. Well, having an attorney like yourself available that, something we can make go away quickly.
I field a lot of calls. I talk to brokers many times a week. Oftentimes, they're literally 5 to 10 minute phone calls.
Mhm.
And it's just a question of, am I doing this right? This feels funny. What should I do? And sometimes I get to say, hey, you're doing a great job. Everything's cool. You're in good shape. Stay the course.
Mhm.
Or, whoa, this is about to be a really big issue. You need to do this now.
Mhm.
And those are the calls where it's like, hey, call the E&O carrier, try this or try that, or get into a mediation or document it this way, or whatever it may be. So it's important to look beyond your immediate sphere when you start to get the tunnel vision. Your managing broker, other more experienced brokers in your community, lean on them. You've got a community around you. If you don't,
Mm.
build that community.
Yeah, absolutely. And so while you're seeing a lot of the non-disclosure issues, I generally find a lot of my other common issues tend to be from operating within the scope of work. And I was just wondering, if you're seeing any of that too. Obviously, that when I brought up the short-term rental
Mhm.
issues plaguing, Summit County stuff right now, when you have agents operating outside of their scope, they may not be aware of these things going on, and being in that area. When agents are just kind of desperate for business, they
Mhm.
tend to take business outside of their general area. And that's one of my concerns that I have too, is seeing agents. I had an agent say to me something about having a listing coming up in Fort Collins, and I'm like, "You're not even a member of the MLS there. How can you service the seller appropriately if you're not even a member?"
Yeah. Or if you're dealing with rural homes and now you're working a high rise condo in downtown Denver.
Yeah,
You got some points with that.
and I've learned for some reason I've been doing more rural lately and, learning that propane tanks for these houses, they're not always owned, they're often the tanks are leased, and I'm like, "Well, what happens if you discontinue lease?" Like, they literally come and dig the tank up.
Yeah.
and stuff like that. And there's just so much that you have to learn. You have to know what questions to ask. The biggest thing I say in real estate is you don't know what you don't know.
Yeah.
Ask is I've just seen some crazy stuff. I was once again representing the seller, had some very difficult buyers, and it came at the last minute demanding a water quality inspection from the well.
Hmm.
And like, how do we find one at the 11th hour? And you're
Yeah.
outside of inspection deadline. So if something comes up, what's going to happen?
Rural areas, water rights are a whole nother ball of wax.
Hmm.
Wells, condition of the well, yeah, propane,
Yeah.
solar panels. There's a lot of
Solar
things.
panels, I can't think of a bigger mistake than
Yeah.
putting solar panels on a home. Love the idea of it. I think it's great. People trying to conserve energy, things like that. It is not, it's far from being perfected yet. We see many issues with
A lot of these.
transferring of ownership, transferring of leases, any type insurance, repairs. I mean, I don't know that I've had a house that had solar on it that didn't have an issue at some point.
I've dealt with a handful of lawsuits and claims because of solar panels, and it's usually because the seller doesn't realize the extent of that lease, the limitations the lease puts on it.
Mhm,
The buyer's agent isn't asking the right questions, and
mhm.
both of them are going in blind. Then it comes to the closing table. It's like, yeah, either A, they don't transfer, or I had one where the buyer wanted to take the solar panels off, and they were Tesla panels. And you can't do
Can't.
that with Tesla. It
No.
became,
They own those panels, and
yeah,
only they can touch them, and they'll respond when they're ready.
yeah, and that was the issue. But
Mhm.
on the expertise side, let me add another topic to that, which is what the brokers know. So many brokers are get into this path after they've had another career, and they're
Mhm.
often very knowledgeable in construction. A lot of lawyers will pivot into brokerage. So I see builders, entrepreneurs, brokers, attorneys, all sorts of people.
I'll pick on you about the lawyer part.
Yeah.
I've come across a couple of those. They're the least fun agents to
Oh, don't get me started. I have opinions. In that staying in your lane, when you're serving as a broker, you are limited to your duties in that listing agreement, buyer's agency listing
Mhm.
agreement. That four corners of that document, that's where you live. I've seen a handful of cases, one in particular where the buyer's agent had a lot of experience in the restaurant business and the bed and breakfast business. And there's a buyer looking to buy a kind of restaurant, that sort of world up in the mountains. And that agent, although very helpful, started to cross the line and is providing a lot of business advice. It was effectively becoming their business consultant.
Okay.
There was no separate contract, and there was no delineation between where business consulting picked up
Mhm.
and ended and where the brokerage picked up and ended. And the deal ended up falling apart. There are all kinds of problems with the business and the property, and the list went on and on. But as that process evolved, the buyers were relying on that agent more and more. And so he got so far out of his lane that when it came down to that seller non-disclosure case and
Mhm.
breach case, and there's a lot going on with that one, the agent paid dearly because not only did he give, bad advice, he forgot to give a lot of critical advice if he were actually serving as a business consultant.
Okay.
So that property purchase ended up turning into a business purchase and a lot of problems that broker became liable. I see it
Mhm.
happen with folks that come out of the construction industry and come into the real estate world, and they start giving advice on inspections and things like that
Ah,
when that's not what their role is. They've got to pivot out, and especially the ex-lawyers.
yeah.
You can't start giving legal advice when you're within your agency agreement. So it's so important for brokers, even if they have that knowledge, even if they're an ex-engineer and they know exactly what that crack means, they need to say, you need to go talk to an engineer, a lawyer, a builder, whatever it is.
Mhm.
Because staying in your lane keeps you protected. You step out of that lane, you're now exposing yourself, which also begs the coverage question is, what if E&O decides, we're not going to cover you because you're acting outside of your scope as a broker.
That's true.
And now all of a sudden you might lose the ability to have that lawyer working for you on the insurance company side.
Mhm. Yeah, I do definitely see that where and the agents have their heart in the right place. They're going over and above. They're
Absolutely.
really wanting to do, but when you leave that brokerage responsibilities, you add more to it, you're opening yourself up to other liabilities that aren't covered under what you're practicing. And so
Absolutely.
and so, yes, I do have to tell people that you need to really step back. Yeah.
Yeah. And even though you want to be helpful and you want to add that information, just have to think if I'm going to add something that's not in the contract, instead of add it, recommend an expert who can.
Mhm,
And then you're off the hook. And then, after that showing, you get under contract,
mhm,
great time for a text. Hey, it's a really cool house. Don't forget about that crack, that issue, that title problem, that question about the easement. Make sure you talk to someone. Let me know if you need a recommendation.
yeah.
You're off them.
Yeah, I think that that's great advice as well. I guess, kind of wrapping it up today, if you had any advice for whether it be home buyers, home sellers, or agents, what would your advice be to avoid having to talk to you?
Talk to me early.
True.
I mean, it's such a broad question in that I think the best thing you can do is your homework on the front end. If you're looking at rural houses, like a lot of folks, particularly as they get to retirement age and they're looking to go out to a rural area and they've been in an urban area their whole life, or vice versa, you're not rural area, you want to go to an urban area. Take the time as the buyer in this case
Mhm,
to pick the right agent, make sure your agent is experienced in that area, just like what we talked about. And you've got enough background information, even if you're a little bit dangerous with it, to kind of know what you're looking at, ask the right
mhm,
questions. For brokers, being mindful of your clients. Do you have a brand new buyer who's going to lean on you heavily and is going to be at their absolute financial limit and they're going to be sensitive? They're going to look to you. If anything goes wrong, they're going to look to you. So that extra TLC, that extra T crossing and I dotting with those brand new buyers is really critical.
mhm.
From the selling side, as a seller's agent, use your instinct. If you start seeing issues within that house, you need to sit down and talk to that seller. You need to disclose this. You're always better off disclosing it on the front end. There's a fear of what if they want to buy it
No,
fast?
I walked away from 2 listings this year because in my conversations with the sellers, I could tell that they were not thinking clearly or not being reasonable with what their house was worth, what needed to be done to it, repair it, and you have to, as an agent, know when to walk away.
That's everything. I once had a wise broker tell me, sellers are the last to learn about the market changes. And it's so true. But yeah, that
Yeah,
instinct, if it's
yeah,
not worth the commission, it's not worth that difficult person.
yeah.
If you feel it on the front end, there's plenty of other sellers out there or buyers for that matter.
Mhm,
Move on. Use your instinct. If you think you can run with it, document it, get help, bring in resources, leverage your team, don't act rashly. And then for sellers, it's all about the disclosures and leaning on your broker for
mhm.
expertise. When in doubt, disclose it. Otherwise, it's a world of problems if you don't.
Well, with our sellers property disclosure used in Colorado when I am working with a seller, which I tend to work with more sellers than buyers these days, and I tell them this is your liability protection. The more you disclose, the more detailed you are with everything, the more you're protected.
Absolutely.
And so they'll ask me often, "Well, do I need to include this? Do I need to include that?" And I think anything, any repairs, any upgrades you've done, anything, and you can say, you know, toilet leak 10 years ago when we repaired it. Disclose it.
Yeah, problem solved.
Yeah,
Yeah, it's
exactly.
the disclosures are absolutely the most common issue that we see. And they see we both on the defense side and the chasing after the seller side. It's
Mhm,
really common. So that is clearly a pain point in the market that a lot of people are feeling and seeing. So
mhm.
with that in mind, yeah, just be careful. Put it out there. Lean on your broker.
Yeah,
Same with the owners. If you have a problem with your broker, and do what you can to end that relationship. And I see a lot of brokers that want to hang on to that potential commission, particularly when, you terminate the contract and there's the holdover side and you go, they don't know about it. I'll get the commission on the back end.
Right.
It's just not worth it. I
No.
mean, sometimes it is, most of the time it's not. Like, no one likes technicality. That's why people hate lawyers.
Mhm.
So if you can get out of that bad relationship,
Mhm.
get out. Otherwise, it's like a bad marriage. It'll just continue on and it's going to get worse. So the ability to control that, particularly when you're talking about any kind of conflict, whether it's between buyers and sellers, between the agents, the one thing you can control is the resolution if you settle it on your own, whether it's the mediation on your own. As soon as you go to court, you have no control. You're giving everything to either a judge or a jury or an arbitrator to make
Mhm.
that decision for you.
Right.
So sometimes resolving the issue early on in a way that you don't like, it's the right business decision,
Mhm.
it's worth it in spades.
Okay, great advice. Now, if anyone out there watching this would love to get some advice for you, how can they reach
My law firm is Gibbs Die, and it's www.gibbsdie.law. Get
you?
onto the website, check us out. You can get a bio on all of us. Get in touch with our wonderful team,
Mhm.
and they'll put you in touch with the right expert for you. And I'm always happy to chat. I answer a ton of phone calls all the time, and I'll always pick up my phone.
Awesome. Well, you're great at that for me.
Yeah, thank you. And you put me in touch with a lot of people, so I always appreciate it.
That's awesome. Well, Andy, thank you so much for joining me today.
Thank you. I appreciate it.